I don't know where he is. Maybe he might have.
Maybe had the last one.
Might be in the bathroom.
Can everybody see? We're going to be, everything's going to be in front of the judge today, so don't worry about seeing the witness. Everybody can see fine?
Yes, sir.
Where's your daddy?
I don't know. Oh, Jesus, Carl. You scared me. You weren't there, and then all of a sudden you were right there.
Did you see all right?
Yes, I did.
I'm mic'd up, but they're not doing anything right now.
No, we'll just play this.
I'm sorry, to who? Channel 30? Yeah, that's fine.
It's just that I don't know. Respect.
Yeah, that's fine. I'll tell them something.
Equal.
Okay.
That's what I was telling Don.
Thanks, Carl. Thank you. Okay, I'll find it. Jesus. Okay, it's good to see you too. Hi.
If you can't see and need me out of your way,
Yeah, I'll just
flip it back.
It is the Huge. Huge. It's Diane's daughter, and there's a trailer next to her. Her, remember, she's
Oh, yeah. Whoopsie daisy. Oh.
Skeeter's his name. Skeeter.
Skeeter is his name. I don't know his real name.
That is. Bryce said that's his real name.
It's on his badge. That's what I said.
That's what I said.
It's on his badge.
My dad is sitting right here.
Also, must be out that
Yes, please, God.
Welcome. That's why you keep me around. I know it's not because I'm so pretty.
That's just an added bonus.
It is.
Yes. Oh, it was good. We had a really good time together. Is that where they went? Mm-hmm. Okay. Yeah. My dad got wasted. He had a great time. Yeah.
You would have thought they'd let you guys go over there and do the jury box. That would have made sense.
That's why they didn't do it. That's why they didn't do it.
Of course.
There's a pretty nice space between the two right there, too.
Tight right here. Oh, Dad. Sorry. He was like, Don't do that. Don't push. Because. Are you smoking?
Mm-hmm. You're good. You got room?
Yep.
Scoot next to his hands.
This way. Oh, thanks. Yeah. I don't know. It's not like, I don't know why. It's not like we can talk during this thing.
We'll do it just in case. Remember, no shower notes sent against the judge. As much as you may want to. I hope you don't.
made for me.
Not your mic, but yes. It's connected. Oh God. Okay. 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 As you're talking to me. It's his facial hair.
He looks old and musty. He looks like the bad guy.
He does.
He is.
This is a real life movie.
1, 2, 3,
He doesn't.
6. 6 bailiffs.
Why are there so many people in here? There's so many people in here.
Well, last time they had 2. Just because it's
Yeah.
actually something that may be final. And she's his sidekick.
Yeah. She is a sidekick.
I like the way he's
She's not very nice.
No.
Stop having this hand again.
All right. We are now going to Walk County in the state of Florida ballot session. Dr. Wallace presiding. The God save the state of Florida and this honorable court. Please be seated. Good morning, Your Honor. Good morning.
Okay, Mr. Phillips is out, and let's call the case of the state of Florida versus Joshua Earl Patrick Phillips. We're here for sentencing on the case where we have, I granted back some time ago a motion to correct a legal sentence, vacating the sentence imposed on Mr. Phillips and ordering a new sentencing hearing be conducted. We did that because of decisions from the United States Supreme Court, most recently in the Miller versus Alabama case. And that case followed on prior decisions in the Supreme Court, Graham versus Florida, and even the Roper versus Simmons case. And basically, the holding has been that it is unconstitutional to impose a mandatory sentence of life imprisonment on a juvenile, even a juvenile who is convicted of first-degree murder, when the punishment for that crime has historically been and provided by statute to be a mandatory sentence of life in prison. To then take a juvenile who's convicted even of first-degree homicide and give him a mandatory life sentence was unconstitutional because of the lack of consideration of the various important ways in which juveniles are different from adults. And primarily in terms of their development, their mental status, their ability to emotional and maturity, ability to appreciate risk, and their susceptibility to their environment and external influences. So before a state court may consider imposing a sentence of life without a meaningful opportunity for release, the court has to consider the number of different ways in which juveniles differ from adults and give a meaningful sentencing hearing to a juvenile to take all those matters into consideration. And then if the court does that, then it may consider whether life imprisonment is an appropriate penalty. And Florida, after these Supreme Court decisions, amended the sentencing statutes to require and then provide a defendant, Mr. Phillips' circumstances, with that opportunity for a sentencing hearing where these factors that are unique to juveniles may be considered. And that's what we have done. We did that over the course of a week, more or less, in August, where I took testimony and heard extensive testimony from experts and other witnesses, arguing that counsel received the memorandum from the attorneys, and then took the matter under consideration. And so that's what I am here to do, to render that decision. I am going to make a few comments here today because I think it's appropriate, and I always think that when I'm sentencing people or ruling on people's affairs and matters, that it's appropriate to look at them and tell them why you're doing what you're doing. I caution you all, particularly because there's so much interest in this case and so much media attention to it, that I'm going to make just a few comments here today, so don't take my comments out of context. In order for you to understand the basis for the court's ruling, I hate to say it, but you need to read my order, which is about 30 pages. I apologize for that. But in that order, I've carefully reviewed the evidence and have gone through each of the statutory factors I am required to consider and to weigh the evidence on those factors and to weigh the totality of all those circumstances to arrive at a decision as to whether it is appropriate to impose a life sentence. If I find that it's not appropriate to impose a life sentence, then I would have to give a sentence of at least 40 years. So rather than mandatory life for first-degree murder, for a juvenile in Mr. Phillips' circumstances, it's mandatory 40 years, but the court may consider up to life. After going through this type of sentencing hearing we've had to consider all the unique characteristics of juvenile, the court then finds that it is appropriate to impose a life sentence. And that would be in a case where it's truly an unusual case, one of a series of different ways they've described it, irredeemable depravity, or the worst of the worst, or circumstances that are truly unique and different from the ordinary. So what I've done then is that sentencing order, I've gone through all the evidence in some great detail and have looked at those factors and arrived at a decision. One thing I will say here, just to put this a little bit in perspective, is I just want to make a few comments about the, I guess, the most significant things that came to mind, and that some of the highlights or the key points in considering the case here. And frankly, it's hard to know what you're thinking about a case like this until you get deep into it and start reading the case law and reading the case law that brought this to us, that is, the Supreme Court decisions declaring unconstitutional the state statutes all around the country and requiring a new sentencing hearing, I think will inform my decision. I'll address that here in just a few moments. But I think, as everybody acknowledged, this is a truly extraordinary case. It had a huge, almost immeasurable impact on the family and the community, and those are factors that certainly have to be considered. The effect on the family and community is one of the factors that I have to consider, and I think everybody acknowledges that the case is almost unique. It certainly is unique in the history of Jacksonville. It was a horrific crime. The circumstances of the little girl and the family, just tragic, and caused devastation among the family and all who knew the family. And then the effect on the community was truly extraordinary as well. It just mobilized the whole community. Everyone was involved. I lived through that just as a civilian, just a member of the public, but the evidence is all there in terms of how extraordinary it was. The case, of course, had to be transferred to Polk County for trial because of the extreme and pervasive pretrial publicity. So in terms of a crime affecting other people, the victims and people who knew the direct victim, this is truly extraordinary. And in terms of the effect of the community, it really victimized the whole community. The thought that something as terrible as this could happen in our community was shocking, and it still resonates in the community. Witness the attention that we have here in the courtroom. So, if you're trying to single out cases in terms of, is this the extraordinary one? Is this an exceptional case? Because the idea is that normally juveniles shouldn't be put to life in prison because of their age, their immaturity, their susceptibility to family or peer influences, their emotional immaturity, their inability to appreciate risk, and just their impetuosity and susceptibility to impulse. And a few comments about this in a few moments about how they don't appreciate the finality of things, such as gun violence, which we see a lot, and which is really the essence of a lot of these decisions that brought forth the law here. So we're talking about those factors, and Mr. Wallace, to his credit, acknowledges that, and his focus, of course, on behalf of his client was on these other factors. But before we go to those other factors as well, the nature and the circumstances of the crime, they're detailed in some length, and maybe too much length in the sentencing order. But with the family here and all of us having lived through the facts and circumstances, I don't need to repeat them in great detail here. But the key thing is that a lot of the discussion along the way has been that this was a mistake, and it was an impulsive decision, and oops, I made a mistake. I was playing with a baseball bat and hit the girl, and now she's hurt. And then one thing kind of leads to another in a series of impulsive, emotionally immature decisions. But I think if you looked at the evidence as it was developed, and some of this was developed more after the trial than actually used at trial, I think there was substantial evidence to believe that the young woman, Maddie, the girl, was lured over to the Phillips home with intent by Mr. Phillips to get her over there. She was not supposed to be there and had no particular reason in the evidence here to want to go to interact with Mr. Phillips or to go to his house. So it looks as if this was a sexually motivated case in which the defendant lured the defendant with a sexual motive involved, and that the killing itself was brutal enough and perhaps was motivated or rose from a concern about not being caught or keeping the young victim from running next door and reporting what had just happened. But what really strikes, and I have to just say some of this, the court in terms of comparing this sort of activity to the other types of juvenile homicides that brought forth the law that we're dealing with here today, is that the level of detachment and the level of deliberateness. The key thing, too, is that the killing, one of the shocking things about it is that Maddie suffered these blows initially. I think it seems like from the evidence the defendant may have thought that she had died, and then I think it was 2 more times realized that she was still breathing or still alive, and then took 2 more stages of blows or stabbings to finally bring her to her death. So you have at least 3 stages, I think 3 stages of blows or stabbings to the child in order to effect the killing. And that is in contrast to some other cases that I'll talk about in terms of, is this impetuosity? Is this the split-second decision of young people with the bravado of a peer group around in a school fight or a neighborhood fight? No, it's something that was done calculatedly, carefully, coldly, with a plan in mind, a plan that goes bad, and then with time to think about what you're doing or do something different. The blows necessary to bring about the death were done in stages rather than one terrible split-second bad decision to pull a handgun out and then in the fray of the combat the handgun goes off and kills somebody. It's very different in that sense. The whole episode then has an attribute to it, as a character to it, that's just so different from the typical juvenile crime that we see. And then not to mention the cold detachment shown after the death of Maddie, and we all are familiar with that from the evidence of the child's body being maintained right there in the very small bedroom where the defendant was, and stayed there for a week or so interacting with people in that room. And just think of the detachment, the coldness to human life, another human being, that's reflected there. And it does demonstrate irretrievable depravity. Then you have to consider, though, and this is a key part of all of this, the age, maturity, emotional capacity, mental health of the defendant, the background, the way he lived in the household, immaturity, impetuosity, ability to appreciate the risk. Of course, he, like a lot of these juvenile crimes, other people participated and egged their colleagues into it, or in a couple of cases where the other persons involved actually did most of the killing. There's peer and family pressure, all those things. And in here, I address that at some length in the sentencing order. And it's a key thing. Again, these comments, don't take them out of context. These are just some observations of some key points, but you need to read the sentencing order to realize I've considered all of these factors carefully. But that, a lot of the abuse that I don't doubt that it was a bad household. By all means, when you look at the Clifton household and then just right across the street, look what Josh had to go through at home, you couldn't see a more sharp contrast. And it's just tragic to see that. And yet, so many children come out of abusive, difficult family circumstances. And a lot of the findings concerning the level of abuse to which Josh Phillips was subjected is self-reported, and then the self-reported statements go into those social science tests or scales. And so I give that weight and consider that carefully. But another thing that comes to mind too is that ultimately there is no real explanation for the level of depravity or detachment or coldness or the callous nature of this. It just doesn't seem to come from the household there, from the circumstances. And there are other children who are exposed to pornography without supervision, who have relations with their father that are sort of cold and authoritarian, and they may have adjustment difficulties. They may have difficulties with maybe sexually inappropriate behavior when they get older, or maybe difficulties maintaining relationships with people, and we may see them here in the court system, and we do every day, because everybody who comes out of those back doors here has circumstances like this in their lives. But ultimately, I didn't find that the social science experts were able to explain how this happened, and Josh Phillips' comments to them, I think, don't seem to come anywhere close to explaining what happened. It's a huge mystery. It's one of those terrible things you think of, where does this sort of behavior come from? And we don't have any good names for it sometimes in the criminal justice world. I didn't find a social explanation for it, sociological or psychological explanation for the behavior. The circumstances in which he lived simply are not such as to necessarily explain or give some indication as to those could be substantial contributing factors. I'm sure they contributed somewhat to his lack of socialization, his isolation. Young people in teenage years, when they're isolated like that, often have thoughts of suicide and so forth. And we see, the point is, we see those children here in court. We see them, we deal with them, go downstairs on the second floor and see Judge Gooding, Judge Bass, and see what they do with those juveniles who've faced those very same pressures in their households. But we don't see this behavior very often, thank goodness. So this comes from where? We don't know. That's the issue. And thus, if the social scientists can't really tell us in a way that's credible, persuasive, then how do we deal with it? And it is important, too, for other considerations such as rehabilitation and just understanding what happened. And that's when I address the rehabilitation in some length in the order. It's I'm left with an uncertain sense of that. He's done well in prison. I commend him for that. The question is, once he's out of the controlled environment in prison, where does that coldness come from? Where does that detachment from other human beings come from? Where does that capacity for unspeakable cruelty from someone who, when you interact with him and see him and hear all the discussions about him, would not interact with other humans that way? But where does that come from? And thus, how do you know when there has been a true sense of rehabilitation? So that lingers and is a concern. But ultimately, when I was going through the analysis, one of the things that helped me was to go back in my own experience as a judge here and to think about the cases I've had. And also, one thing that helped me too is I actually went back to the case themselves, the Miller versus Alabama case, and looked at the facts and circumstances there. And if you do, you see kind of a different picture. And what you see, and these are the cases that the court in Washington saw and led the court to conclude that it is simply unfair and ultimately unconstitutional to apply these mandatory life sentences that are imposed for adults to juveniles and sending them away for life without thinking through the whole process of how a juvenile may be different from an adult. And only if you do that can you say that a life sentence without parole opportunities or meaningful opportunity for release would be constitutional. Because just to give a juvenile a mandatory life sentence the same way you would as an adult is just is fundamentally unfair. And if you read the case law, it makes some sense. But also then you go look at the case law, what are you dealing with? I was struck here in Miller versus Alabama, you also had a Jackson versus Hobbs. They were companion cases. And if you read about young Jackson, he was sentenced to, I think from Arkansas, was it? A mandatory life for what we call felony murder. That is when you participate in a robbery and someone is killed in that robbery, you're guilty of murder. And you may be guilty even if you went to the robbery not knowing your accomplice had a gun and no way intending that anybody shoot anybody. But that if you're participating in a robbery and one of your co-participants kills the store owner, say, then you as a co-participant in that robbery are liable for first-degree felony murder, the same as if you intended to shoot that man under a lot of state law. And that's what Jackson's situation was. The evidence showed that he did not realize that anybody had a gun until they were just into the store. He was not the shooter. And so the court, that his case was one of those cases that held that it was unconstitutional to impose the life sentence on Mr. Jackson without going through the process that we've gone through here and understanding, what his life circumstances were about. Because think of how momentary and impulsive a decision like that can be when you have these young kids in their teen years go in to rob a store, probably not planning to shoot somebody, but reacting to the stimulus of the moment, somebody panicking and somebody bringing out the gun. And what these young people don't realize is the guns are final, and that when you shoot somebody, they don't come back to life, and the consequences are lifelong. But that was Jackson versus Hobbs, companion to Miller, the case that brought us here today. And you look at Miller versus Alabama, and that defendant grew up in a home with demonstrated very bad child abuse. He was in and out of foster care. His mother suffered from drug and alcohol addiction. His father and stepfather demonstrated regularly abuse him. That's why he was in foster care. He regularly used drugs and alcohol. He had attempted suicide 4 times. He committed a homicide against an adult friend, but he did it with a friend. And then the friend pled guilty to a lesser offense and then testified against Miller at trial. Miller was convicted of first-degree murder and sentenced to life in prison. And the circumstances were a little aggravated. It was a heinous sort of set of circumstances that Miller committed. But again, you have a set of circumstances such as that led the court to say you cannot just automatically impose life sentences against juveniles. In my own experience, right here in this courtroom and others around here, I found all these right here in this courtroom. I've reviewed and interacted with a man who's in prison for life. He originally got the death penalty, and that was set aside. But he was 17 years old at the time. They were at a Arlington pool hall, and there was some type of confrontation, like 2 different groups. A lot of this, this is peer pressure, the classic thing in these factors that you're supposed to look at in terms of how juveniles are different from adults. And there was a confrontation, kind of one side against the other, and he had a gun apparently and pulled it out and shot another. And so there's a death right there outside that pool hall. But that 17-year-old, much like Mr. Phillips, has done well in prison. He's a master plumber, runs a plumbing operation at the correctional facility, and he is a a master law student wearing us out with the paper, and he comes here with briefs and papers, and he's doing his own resentencing hearing. So he's up for consideration, and you have to look at that. That is, he had the peer pressure. It was a split-second decision made under those types of circumstances. So that's something to be looked at seriously in terms of whether a mandatory life sentence is appropriate for someone in his shoes. And I've had similar ones where I had a neighborhood confrontation where two young men, they were late teens, or older than Mr. Phillips, but still either juveniles or right after the juvenile 18-year level. But it was a neighborhood confrontation, and there was a fight, and both sides were kind of watching it and setting up these two young men had to kind of earn their manhood by fighting one another. And rather than just being a struggle and a fist fight like it was anticipated, one of them had a gun, and when things were going wrong, pulled the gun out, and in the struggle, the gun goes off, the other man's killed. So, that's the kind of crime that is created, and you can see that it was committed because of the attributes of being juveniles. They're impulsive, impetuous, they're emotionally immature, they're influenced heavily by peers and the bravado of being a big person in a group and having to go prove yourself in front of your peers. And I had a case just recently, we tried it some months ago, similar thing. There's a confrontation because these are young people, like they're teens, disrespected another, and so they're going to go have a fight. And the two sides came to this intersection in the neighborhood to have a fight, and one of the young men panicked, thought somebody else was getting ready to shoot him. He pulls a gun and shoots somebody. So there you have it. It's these are young kids in the neighborhood elevating personal dispute, and what we used to think of as just fights that would end and everybody go play ball with them after they've exhausted themselves struggling with one another. But because someone made that fatal decision to bring a gun to the affray, then and that gun has such finality, then we have a death, and we have the law the prosecutors would prove would show enough premeditation to show a homicide, and they would call for a major significant sentence. But it's a lack of appreciation for the risk, what it means to have a gun. When you pull the trigger, it's forever. And that person is going to be dead, and you, as the person who did that, have to bear the responsibilities of that for the rest of your life. And those are the kinds of crimes that we see in court day after day after day, and indicative of juvenile activity. I used to say that stealing cars is a young man's game. They're out there. They don't appreciate the risk. They can't appreciate what they do to other people. They're egged into it, particularly by other people, and all these influences that you see spelled out in these statutory factors weigh into that. I say this in no way to denigrate anybody here, but the effort made by the social scientists, experts for the defense, was solid, and I appreciate it. And they're experts in their field, and I appreciate their expertise. But ultimately, it appears that an effort is made to take Mr. Phillips' circumstances and to fit them in the circumstances of these other cases where the courts have found that the actions of the young defendants were caused by, or at least major consequences of, attributes of youth. Again, being influenced too much by your home that you can't get out of, or influenced by peers, and influenced by emotional immaturity, and by the failure to appreciate risk and the lack of impulse control. Whereas, I hate to say this, but what you see here in this case is just a very different picture, one in which that I don't think can be explained by the attributes of that are inherent in and are particularly applicable to juvenile crimes. So, with that, with sadness and feeling difficult to go through with this, I have concluded, and I explained it in detail in the sentencing order, why I do feel, having gone through the evidence carefully gone through all the statutory factors, I believe that this is one of those rare and unusual crimes where the circumstances are such as to warrant life in prison. And that's even with a man who committed these acts when he's only 14 years of age. And Mr. Phillips, I say this to you, as I'm condemning the actions and talking about how they constitute depravity and they're heinous and all those things, I'm not doing this to denigrate you as a human being or to humiliate you further in front of everyone, but and I can distinguish you from the actions and the faith traditions that underlie the country here. There's a distinction between condemning actions and condemning the essence of the being of the person. And I've been in the criminal justice world long enough to know that all these people who do these terrible things that we see here, so many of them have a human and good side to them. Their parents come up here, their brothers and sisters and people, and they come up and describe really acts of great humanity from people who have done otherwise terrible things in the world. And by saying this, it's not to say that this court is not in a position here to condemn you individually. It's just to make a statement that when there are actions that occur of this nature and circumstance, and they have this level of effect on the community and individuals here, and when they reflect a inability to appreciate basic humanity in other people, they demonstrate a level of culpability and a potential for harm that warrants the severe sanctions. And the other last thing I conclude with, and that is the actions of the family here in terms of they have urged me not to impose a sentence that would permit Josh Phillips to have freedom. We don't allow the victims here to decide what happens. That's why we have a court. But it is important to think about the impact of the family and the community as to making a statement or having the court appropriately express the societal response to what happened here. And I think that's what makes this appropriate as well, the idea that this was such an outrage, this so affected the community, that the idea that the perpetrator would be out perhaps among the community again is such that the community would be continued to suffer from that collective experience. And so I think that's a relevant factor as well. The circumstances here are such that that they're permanent, lasting, and profound, and that this truly is one of those rare cases where the life in prison sentence is warranted. And I say here in the end of the sentencing order on page 30 that this is indeed the uncommon case that qualifies for a life sentence. And I was reflecting this, I've seen this in other orders in and around the state, and they'll say, well, this crime, it doesn't deserve life, what does? But I think, well, this really is that sort of case. This is an extraordinary case. And if you were to find that you could not sentence someone to life in prison for this crime, I think the idea would follow that there probably is no juvenile homicide crime that would warrant or justify a life sentence. And that it really is contrary to Holy and Miller that rejected an automatic or mandatory sentencing standard in favor of one that takes into account individual characteristics of the crime and the offender. So when you do take account of those individual characteristics here for all the circumstances as outlined in the order, I think this justifies the sentence of life. And again, it's a sad day because I'm not unmindful of the fact that he's 14 years of age, and that to lose your freedom of something you did at 14 is extraordinary. And that's why we've gone to this effort to have this hearing while the Supreme Court ruled the way it did, while the Florida legislature acted and passed the sentencing scheme that we did, and why I think this is rare. I don't think this is going to happen that much. Those other cases I described to you are such that, absent something unusual, I would think that those cases would not warrant a life in prison. But in these unique, compelling, extraordinary circumstances, I think that they do. So with that said, I'll ask the defendant to come forward. Yeah. And we have an interesting technical point. The judgment here is from Polk County in the 10th Judicial Circuit. Normally, I would maintain the adjudication and just re-sentence him, but I guess we'll impose a fourth judicial circuit. The jury verdict stands, so we have a jury verdict that was rendered back when it was. And so based on a jury verdict, the jury found the defendant guilty of first-degree murder, and so the court then again adjudicates the defendant guilty of that crime as charged in count 1 of the indictment. It's 782.04 subsection 1A of Florida statutes. And then it's the sentence of the court, and as for the reasons stated in the sentencing order to be entered on the same day, that this defendant be sentenced to a term of life imprisonment in the Florida prison system under custody of Florida Department of Corrections. He will have the time served credit that he's entitled to be computed by the Department of Corrections, and there are court costs of $200 for the Criminal Justice Fund, $50 for the Crimes Compensation Trust Fund, and $3 for the Criminal Justice Standards and Training Trust. There had been a restitution order referred to, but I see no restitution in the record, and no one has brought any of that to my attention.
The arrival was previously tendered, I believe, but I'll check to make sure.
Okay, well, I'll reserve jurisdiction. I think I have 60 days in any event to enter a restitution order. Hi, Mr. Phillips. It's a sad day for me. I have had to go through this process, and I'm just trying to do my duty the best I could. And I do wish you well. I think there is an opportunity, even with life in prison, to have a meaningful life. And you've made some statements and some movement in that direction. And so I urge you to continue in that direction. And I think you can find, I do hope you find some meaning and purpose and make a difference in some other people's lives there. Okay. In that sense, I need to tell you that this is Judgment Day, so you have a right to appeal. You have a written notice of appeal must be filed within 30 days, and an attorney will be appointed for you for that purpose upon request. Okay.
Well, I would ask you at this junction to appoint another attorney at this junction for that purpose.
Okay. I will do that. I don't have someone right in mind now, but we'll do that in the next day or so, appoint somebody. Should it be the public defender initially?
No. This was a JAC appointed. I would suggest if Mr. Sickler is available that he be a perfect
okay, I'll pay attention to that. We'll get that done promptly. Okay. You need to, it won't be a problem. I'll get it done right away.
I'm sorry.
You'll need to pay attention to it as trial counsel.
I'll file the notice.
You file the notice and make sure you perfect the appeal, and I'll make sure appointment is done promptly.
Okay.
Okay, thank you. Okay, we'll stand adjourned. Thank you.
Yeah.
Yeah.